All right, everyone, we start off today talking about the U.S. Supreme Court. We got Moore v. Harper the other day. This is the case over the theory of an independent state legislature with regards to election rules. So the theory goes that state legislatures effectively can do whatever the hell they want, and they can't fall under any form of judicial purview because it's a power specifically for the state legislature. So if they want to impose some sort of rule, if they want to manage at the state level basically everything regarding elections, there's nothing that anybody can do about that. Now, this is a case that I genuinely believe that the Supreme Court should have bounced and allowed it to perpetually remain a patchwork situation in the country where they refuse to weigh in and therefore lower court rulings hold firm. So in some areas, probably blue areas, judiciary bodies would have undue power over the legislatures and their free action, which is granted to them in a fairly explicit sense to manage elections. In other areas, absent any judicial oversight whatsoever, which is what you would get in the rest of the country, state legislatures could do all sorts of zany shit, including blue state legislatures, and there's nothing that anybody could have done about it. The problem with even judging the case is that you obviously in your decision making, even if you restrain the judgment, and they didn't so much here, they went more broad, you're effectively handing undue control to one pole or the other without the hope in either situation that there's any form of oversight from the other body. So you're either, as they did, you're either subjugating the natural legislative right to generally run elections to judicial bodies, so a random activistic judge can come in and say you can't do that, injunct it, drag it out, and potentially interfere with elections thereby, which is probably going to become a goal in the 2024 election in some states. Or, absent any constitutional overview, you can have a genuine violation of the constitutional rights of people within a state by their own state legislature, and SCOTUS would have been blocking any state courts from even acting, from having any role in stopping that, and they would have to use a million legal workarounds in order to try to stop actual abuse. The problem is that there was no way to have a proper ruling. It's a 6-3. Kavanaugh, Coney Barrett, and Roberts all joining with the three liberals on the court actually on this issue. The others dissenting, of course. You can't expect Neil Gorsuch to vote in favor of such a thing. He tends to be a hands-offer in the most strict sense. I'm not happy with the decision, but I think I'd be equally unhappy if they had gone along with the basic concept of an independent state legislative body in the first place. Again, the problem is that either way you open a can of worms on the election system in the United States that doesn't really need to be. You are capable of finding balance. Absent the Supreme Court decision being more broad, you could say, okay, generally the legislatures can do what they want, but there are some circumstances in which quite clearly they're overstepping, they're literally violating the rights of their own citizens to vote, like if you instituted like a poll tax or something like that. You could have any number of ways in which you disenfranchise voters. You'd have voter suppression. On the other end, you get potentially voter fraud because you've opened up states to activistic judicial purview by individuals who, in many cases, have partisan leanings. We see this all the time, by the way, on courts. When you have a multi-judge panel coming to 5 different conclusions with regards to a piece of potential legislation or the legality of an idea, it shows you that while the law is supposed to be relatively ironclad, it's being deliberately made to be as vague as possible and therefore up to interpretation. By the way, this is definitely one of the roots of differential enforcement within the United States. Two seemingly very similar phenomena can be judged legal or illegal, proper or improper, based on who the defendant happens to be. This happens all of the time. So the independent state legislature theory has failed. Again, 6-3, so this wasn't a close split decision. It was a beefier decision that they made. Not along partisan lines. 2 conservatives and 4 liberals. I consider John Roberts, by the way, to be generally a liberal individual. Bush appointee. Look where the Bushes are politically these days. Need I say more? But I was going to be unhappy with the decision regardless. I think I made a video months ago on the topic saying they shouldn't have even taken the fucking case up, because now they've opened up a can of worms. You will see judicial activism in some states. It won't be necessarily very widespread, at least at first, but it will happen. and now the state legislatures won't be able to really do anything. Effectively, states might have to amend their constitutions because part of the purview that's put in here is specifically a reference to that. Well, there's still the state and the federal constitution still have to be respected in the legislative decisions. Under that auspice, of course, the courts can use their normal legal judicial purview to look at what the states are doing to determine whether one of their election-related actions, which would otherwise be allowed, is violating constitutional rights. But as we see, there's always a public conversation on every goddamn aspect and nuance of the Constitution, federal or state, even where the language is resoundingly clear. Hundreds of years have gone by. Do people actually have a broad, sweeping consensus of what it means that Congress shall establish no state religion, nor interfere with the free exercise thereof? No, of course not. It's interpreted 7-8 different ways, often with preference for one religion over another, you'll notice. What about the Second Amendment? It's cut and dry language. The right of the people to keep and bear arms shall not be infringed because a militia, which is an armed population, is important for maintaining things. You couldn't be more clear. As long as you understand a couple of archaic linguistic terms that are used in a different context today than they were in the 1700s, it's cut and dry. But we've never come to a full understanding. A purist like me understands exactly what it means, but there are still people that debate the issue endlessly. Where does the arbitrary cutoff for violating the rights of the militia end? The states don't agree on these things. What you're going to get is therefore differential usage of state and federal constitutional law influencing the elections in those states. Likewise, it wouldn't have mattered if they had voted in favor of the independent state legislature theory, because then you would have out-of-control legislatures using that as a cudgel. They would have said, well, without the judicial system being able to weigh in on what we're doing and we can do whatever we want, well, we've got a super majority of Republicans, or of Democrats, by the way, in the State House. We can do butt-fuck whatever we want. This is great. We're going to shut the other party out forever. You'd end up with one-party rule in the more partisan states. Then nobody would even bother campaigning in California anymore. You think they wouldn't take advantage of that? They wouldn't campaign in California. They wouldn't campaign in the deep red states. Wyoming would be off the table. You'd end up with a permanent two-party strangulation, and those parties are neocon, neolib, Inc. run at the moment anyway. So effectively, you get no choice perpetually for your elections. It'll always be a rehash of 2004. Oh, Bush versus John Kerry. What a great decision. Choices are hard. Freedom is great, isn't it? Democracy. So, I'm disappointed, but I would have been anyway. The only thing that wouldn't have disappointed me in more v. Harper is if they hadn't taken the fucking case up in the first place and at least kicked the can a little while longer. And I am reluctant on can kicking, generally speaking, with regards to judicial decision making. So when I'm coming out and saying that, it's probably a stinker. That's about all. Peace out.